Well, hi there, Mr. Daly. Good morning. This is Judge Anzalone. I'm ready on Eduardo Benavides. Are you there?
For Benavides?
Yes, Eduardo Benavides.
Got it.
Okay, thank you. Bye. All right, Mr. Nolan, can you hear me?
Yes, ma'am, I can. Good morning.
Good morning. So this is in the matter of the people of the state of Michigan versus Eric Joseph Nolan. We have two files, 24-21927FH and 24-21928FH. Mr. Nolan, we're here on two things. A request and warrant for probation violation. There's one on each of your files. The allegation is that on or about February 6th of 25, you tested positive for the controlled substance THC, and that on that same day you tested positive for alcohol. And that's on each of your files. On file number 24-21927FH, you're on probation for attempted RNO, which carries a maximum penalty of up to 1 year in jail. And then on file number 24-21928FH, you're on probation for controlled substance possession of analogs. And I think that is, yep, that's a 4-year felony. No, that must have been a plea offer. So hold on, let me get that. Is that a 4-year, Mr. Jones?
I believe it's 2 years, Your Honor.
Okay, I think it is. Yeah, it looks like there we go. There's the amended information. I missed that. Okay, so that carries a maximum penalty of up to 2 years in prison. So, Mr. Nolan, you do have a right to have an attorney represent you here today, and Ms. Underwood is here today to speak with you if you'd like. Would you like her appointed to talk to you and represent you?
Yes, ma'am.
Okay, all right. So I am, and Ms. Underwood, he is a member of our recovery court, okay?
Okay.
Did you hear me, Ms. Underwood? Yeah.
He is in recovery court, Your Honor?
Yes, ma'am.
Okay, did I see, does he have a parole holder as well?
He is on parole, yes.
Okay.
Okay, so Ms. Underwood and Mr. Nolan, go ahead. I think Mr. Nolan goes automatically. There we go.
Dave did put a parole detainer on him as well.
Okay. All right, Mr. Benavides, good morning. So, Mr. Daly, are you ready on Mr. Benavides?
Yeah,
all right, so I'm gonna grab his file. Okay, this is in the matter of people of the state of Michigan versus Eduardo Benavides. We have two files, 24-21986FH and 24-22076FH. I have James Daly appearing on behalf of Mr. Benavides. Mr. Daly, I'm sure you saw this, but he did not wish to, we did review to see if he'd be eligible for recovery court, and he didn't wish to partake in it.
I hope he's changed his mind, Your Honor. I talked to him again last week. He tells me that he thinks he's doing fine. He tells me that he thinks the best thing that he can do is spend another about 140 or 50 days in jail and to walk away and not have this. I have told him that the only thing that's happening here is that people are trying to provide some benefits to him so they don't see him back in the courthouse again. I've tried to explain that to him. I've talked to him about it, but I really believe that he doesn't believe there is a problem, even though the test would indicate there was a problem there. The only thing that I would suggest, Your Honor, is I've already told him that jail is a certainty. I don't know whether the court would release him with him knowing with certainty that he's going back to jail, that if he uses drugs, if he does anything else, are those going to be the consequences? He thinks that he's going to be all right. I'm not so sure about that, Your Honor.
This guy the prosecutor or the judge, the lawyer?
So, Mr. Benavides, have you had an opportunity to read through and talk and review your pre-sentence report and talk about it with Mr. Daly?
I haven't even seen the paperwork or nothing. I haven't seen nothing.
Okay. Was it?
I had it over with him. He didn't want to keep it.
All right, Mr. Daly came, hold on, Mr. Benavides. So Mr. Daly came over to the jail to meet with you?
He came, yes.
And he had the pre-sentence report with him and he talked to you about it?
No, he did not. He didn't have no paperwork, nothing with him in his hand. All he had was his, a bloody napkin and his cane.
Okay. Do you want an opportunity to read through it?
Yes.
Okay. All right. Mr. Daly, what else do you have this morning?
I've got to be downstairs.
Okay. So what we'll do is we'll send a copy of this over to the jail. And when you're done downstairs, just come back up.
Thank you, Judge.
Thank you, Mr. Daly. All right, Miss Adams, when you get a chance, we'll, if you could send a copy over to the jail. All right, Mr. Benavides, we'll have a copy sent over to the jail for you to review, all right?
All right.
Thank you. You're all set. Okay, and okay, we'll just wait for hey, you need him back?
What's that?
You need back in the jury room?
I was hoping to chat with you about 9 o'clock. Scott sent me in to talk to you, but I don't want to interrupt what you're doing.
No, because the other party's not here.
Yeah,
So-
he paid. We resolved it at mediation.
If you want me to call it, I can call it.
Okay, yeah,
Okay.
we were just gonna ask for an adjournment without date because it'll.
When you step up to the
Sure,
podium,
sure,
because
sure.
we're on the record. All right, in the matter of Daniel Hartley versus TG Cook, file number 23-237145 CK. I have Amanda Wagner appearing on behalf of the plaintiff. This matter was set for 9 a.m. So, Ms. Wagner?
Yes, Your Honor, at mediation, we came to an agreement and then the other party, Mr. Cook, had dropped off and we weren't able to get connected back with him, so we weren't able to put it on the record at that time, but then Mr. Cook showed up at our office several days later and dropped off a check. Our client hasn't cashed that check yet or deposited it, so we were just going to ask for an adjournment without date to allow him to do that. And
Okay,
then it would be dismissed at, as long as that check clears.
all right. So let me give you a date though, because I have to keep it on my calendar. Ms. Adams, could I get either a pretrial? I can do a pretrial on a Monday or a Friday morning settlement conference about 30 days out.
that card as well.
Can I get a pretrial or a settlement conference date with today?
$100 from your account.
Mr. Nolan, give me just a minute, all right?
Yes, ma'am.
For a settlement, Judge, we can do March seventh.
Hold on, Mr. Nolan, hold on, everybody. Mr. Nolan, I'm gonna put you in the waiting room for 1 second because of the background noise, so give us a second. All right, Miss Adams?
For a settlement on Friday, March seventh at 9 a.m.
All right, we'll put it on for March 7 at 9 a.m. Obviously, if you nullly or dismiss it, then you're not a prosecutor anymore, so you don't nully cross things, but if you dismiss it, that date won't, you won't have to appear.
Thank you.
Can you do the notice?
Yes, absolutely. And we'll, I'll have my office try to get a hold of Mr. Cook and let him know too.
Okay, if he shows up, I'll let him know.
Thank you so much.
All right, thank you.
Have a good weekend.
You too. All right, I'm gonna let the jail back in, Miss Underwood. Maybe.
Hopefully not late.
No, give me just 1 second. Will you go tell him what happened? We'll be back. It'll be a little bit before we come back with him. All right, hold on, Miss Underwood. I gotta close. Jail room. All right, so we are back on the record with Mr. Nolan. So Miss Underwood, how would you like to proceed with Mr. Nolan?
Mr. Nolan wishes to accept responsibility and take a plea today, Your Honor, to the technical violations.
Okay, so Mr. Jones, Mr. Face is his parole officer?
That's correct, Judge.
Okay, all right, and so if he takes a plea on this today and we set him for sentencing next week, we're not quite sure what will happen with the parole violation, correct?
Correct. Once everything's settled, then it's available for the parole agent to deal with the violation on his end.
But if he's continuing in recovery court, that would work in his favor, right?
I would imagine so. I think Mr. Face is over in the office today. But what you're saying is correct, I do believe.
Okay. Okay, all right, so Mr. Nolan, can you ask them if you can close that door just a little bit?
Yes, absolutely. Hey, if Adam's not there, I'm gonna shut this door. They can't hear. Thanks, Nolan.
Thank you, Mr. Nolan. All right.
Oh, yes, ma'am. Absolutely.
Raise your right hand for me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
All right, so Mr. Nolan, you would ask for court-appointed counsel. We appointed Ms. Underwood to represent you. Are you satisfied with her as your attorney and the advice that she's given you?
Yes, I am. Absolutely.
All right, you can put your hand down. I'm sorry.
Okay.
So do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes, I do.
Do you understand that throughout the hearing, you would be presumed innocent till your guilt is proven by a preponderance of the evidence?
Yes, I do.
You have a right to have all the witnesses against you appear at your trial, and you would have the right to have your lawyer ask those witnesses questions, ask them yourself, and to have me order any witnesses you might have to appear. Do you understand all of that?
Yes, I do.
You do not have to testify at your hearing, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
I do.
On the other hand, do you understand that you have a right to testify at your hearing if you want to testify? Do you understand that?
Yes, I do.
How do you plead to the charge that you violated the terms of your probation by testing positive for THC and alcohol on February 6th of 25? Guilty or not guilty?
Guilty, Your Honor.
All right. Do you understand by pleading guilty, you'll be giving up the right to a trial, as I've already explained to you?
Yes.
Has anything been promised to you to get you to plead guilty?
No, ma'am, nothing's been promised.
Okay, has anyone threatened you in any way to get you to plead guilty?
No,
Accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
yes, I do.
All right, so, and it's your own choice to plead guilty, correct?
Correct.
Okay, so Mr. Nolan, you are on probation currently. It was with Sarah Teskey right now. Mr. Moore is covering. So one of the terms of your probation and term of recovery court is you're not to use any illegal controlled substances or marijuana. Is that correct?
That is correct.
All right, and on February 6th of 25, you tested positive for marijuana and fentanyl. Is that correct?
That is correct.
All right, and then you also tested positive for alcohol. Is that correct?
No, Your Honor, I did not test for alcohol. I did test for THC and fentanyl. I'm not sure where the
Well,
alcohol
it
came
showed
in.
up. Well, it showed up that you had alcohol in your system. Had you drank the night before?
No, I haven't drank in years, ma'am.
Okay, all right. I'm fine. Just I'll strike the second violation. Just proceed on the first one because anyway. All right, and you knew you weren't allowed to use marijuana or heroin or fentanyl. Is that correct?
Correct.
Okay. Accept the plea. It has been given understandably, voluntarily, and accurately. He has full knowledge of his rights. He does have competent counsel. I'll refer this matter to the probation department for a pre-sentence investigation. And Ms. Adams, can I set this for sentencing on February 13 or 14?
Judge, February 14th at 8 a.m.
All right, so Miss Underwood, are you available February 14 at 8 a.m.?
That's fine.
All right, so Mr. Nolan, Mr. Moore will do an update to your pre-sentence report or to probation violation report. We'll see you back next week at 8 o'clock in the morning, all right, on the 14th.
Your Honor,
Okay, no chance of a PR bond, huh?
You got a parole detainer on you, so, and we'll keep you in custody. We'll probably be sending you to rehab, so. Yep. Anything else, Ms. Underwood?
you answered my question, Your Honor.
Okay, all right. We'll see you back next week, Mr. Nolan. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Yes, he's either hanging on up here. Getting out?
No, Ms. Underwood, I believe you're gone. Nope, she's gone. She's gone. All right, so. I have Martinez and Rowley, but I do not see Mr. Dagger-Margosian yet. So. I'm going to make a recess till we get somebody. Let me find out who this person is real quick.
You want me to go on the record, Judge?
You can. I just have somebody in my way. Just rename them. Hi, I just let somebody into the Zoom room. Can I ask your name, please? Go ahead and unmute your device.
Yeah, my name is William Martinez.
Mr. Martinez, Mr. Dagger-Margosian is down the hall right now. So I'm going to change your screen name and then put his initials after it. And then I will put you back in the waiting room. And when he's done down the hall, I'll bring you back in, okay?
Okay.
Thank you.
like to do this with some kind of a hook, tie and hook on this. And this chair.
Oh, yeah, that's a good idea.
Flip it over, so
Okay.
I never seen that. So.
Hi, Michael.
I'll let the judge know you're here, Michael. Okay. Your client's on Zoom.
Mr. Rowley?
No, Mr. Martinez.
Martinez. And then, is there a sentencing on Eduardo?
Mr. Dick, no, they sent the PSI over to the jail for him to review it. So Mr. Daly's gonna come back after he's done, I think, maybe in this report. He's gonna come back.
Are you on that one too?
Yeah, well, so Jim and I are both on that for one case. So, I mean, I can be here, but it's gonna be the same sentence, right? I imagine it's gonna be the same sentence, so.
Did you
whatever.
talk to Mr. Benavides?
No, but I can,
Okay. Okay, so I have Mr. Martinez. I do not have Mr. Rowley. Okay, which one do you want me to call first?
Martinez, and then is it okay if I talk to them on Zoom?
Yeah. Do you want to go back to the jury room?
Yeah.
No. Mr. Martinez, Mr. Degger Margosian is going to log into Zoom so he can chat with you for a minute, all right?
Okay.
All right, you should get an invitation to join a breakout room. Go ahead and join that breakout room.
Okay.
We're back, okay. I know Mr. Daly went downstairs and we sent it over. Okay,
I went and talked to him, he's talking about, he's gotta read the PSI. That- He said, because I talked to my brother, I talked to him, and at that time, they said, when I talked to that lady, he said that Daly was gonna go over there and go to the PSI and drop the paperwork. When I called my brother, he said, yeah, Mr. Daly left, and I said, did he drop any paperwork? And he said, no.
okay, well,
He said that he did it, and he said, well, okay. And then I spoke to an officer that they verified that he saw, that he never saw Daly.
so we're kind of on the record, so we can't really chat, but as long as we're on the record, so I'm sure they'll go over it now. Well, they'll have plenty of time.
He said as soon as they're reading it now.
Yeah, so we'll
So the sentence, it is happening today, right?
yes, yeah, it'll just be a few minutes.
Is it possible to get his name?
Huh?
Can I get his name?
Mr. Benavides?
Yeah,
Oh, can you tell Ms. Spade your full name for the record?
Richard Benavides.
thank you.
I'll figure it's Friday, the court's not gonna be full.
Would be what?
Full.
No, we're never full anymore unless there's something really bad going on. No, everybody zooms in now.
Better like that.
It's easier on the people, I think. They don't have to drive or find childcare or, so I think it benefits people, you know.
Now these days, everything's based on the phone anyway.
No. Ready for me to bring him back?
Yes.
There it is. Okay, so we are on the record in the matter of the people of the state of Michigan versus William Antonio Martinez. Mr. Jones, I would just say there is a typo on page 1. His name, William, is spelled wrong. I'm waiting for Mr. Jones. You have W-I-L-L-I-L-A-M. I think that's third L is supposed to be an I. You're muted.
On the evaluation plan?
Page 1, defendant name.
Oh,
The L, third L come out. Okay. So, and it's file number 24-22071FH. I have Michael Dagger Margosian appearing on behalf of Mr. Martinez. I have neither a prosecutor nor anyone wishing to speak today on this matter. Mr. Dagger Margosian, there was a Killebrew agreement on this between the prosecutor's office and yourself, and the court will, of course, honor that because it's a Killebrew agreement. So, Mr. Martinez, have you had an opportunity to read and review the pre-sentence report?
Yes, I have.
I'm gonna need you to either, you need to speak up more so we get a good recording, okay?
Okay.
All right, thank you. So you've had an opportunity to read it. Have you had an opportunity to discuss it with Mr. Dagger Margosian?
Yes, I have.
All right, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes, I am.
Okay, Mr. Dagger Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, ma'am.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my knowledge at this time, Your Honor.
All right, the probation department calculated the minimum sentencing guidelines to be 0 to 3 months. Do you agree with that calculation of guidelines?
Your Honor, I have no challenges at this time.
Okay, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Martinez?
Your Honor, I'd ask you to, for the most part, follow the recommendation. I think it's appropriate, also given the sentencing agreement reached between myself and the prosecutor's office. I will point out that the recommendation of 5 years probation, I think I've done the math right, is 20 times higher than his guidelines maximum. It just seems a little outrageous to me for that recommendation. I understand, given the underlying conviction, that may be the potential reason for that recommendation. But again, I just, with the guidelines, and also paired with the fact that Mr. Martinez, in reviewing his PSI, there is one criminal conviction from 2008, nothing before, nothing since, up until this instant offense. I think that should play a factor in this court's decision for the length of time for probation. The last thing I'll make note of is the substance of this offense involved messages to a decoy, and so in other words, there wasn't even a person on the other end. Whether that, it's certainly not an excuse, obviously, but I don't know. I think that should also be a factor involved when determining the sentence. Regarding the, and I guess I'll also make note that Mr. Martinez, by statute, will be required to be on SORA for 25 years, and so there will be significant and long-term supervision of that nature. So what I'll say is, this court has heard me make this argument before, but regarding the recent amendment to SORA, removing some of the requirement conditions. What I don't like is when probation tries to bootstrap conditions that were taken out of the SORA requirements, but put it in by way of probation conditions, and namely,
which one are you talking about? Number 5?
I have it written down in my notes of the school zone. So if that's the one the court is referring to.
Within 500 feet of parks, municipal swimming pools, playgrounds, childcare centers, preschools, arcades, or places primarily used by individuals 17 or under. Is that the one?
Yes, yeah. That's one of them. Another condition I think would be appropriate for the court to strike would be the no alcohol provision. Alcohol is not involved here. It's obviously sentencing must be specific to the individual and the offense. Obviously, if it's ordered, that Mr. Martinez will comply with that. But in any event, I just wanted to raise those concerns to the court. And other than that, the court's discretion.
Okay. All right. Mr. Martinez, is there anything you'd like to say in your own behalf?
No, I don't.
And Mr. Jones, I didn't know if you wanted to weigh in on probation term number 5. I can see the alcohol clause. We don't show any prior history of alcohol issues. I could see striking that, but anything else you'd like to weigh in on, Mr. Jones?
just the fact that it was, I mean, the conditions that the attorney's talking about was not removed from SORA. If you go read the SORA statute or the what I'm supposed to follow, the court is the only one that can order those requirements. And I'm required to put those in my PSI, and the court can make that decision whether those restrictions should be imposed. That's the only reason those are in there. To the general public that's still on SORA, yes, those restrictions don't apply. To a parolee, those restrictions don't apply, but the court is the only one that can impose those sanctions for SORA requirements while under supervision. So what's being said really isn't totally accurate, is that that's still 100% enforceable within the Sex Offender Registry Act.
And basically, it's at the discretion of the court.
Correct, and I want to make sure that I'm not being misspoken for. It was taken out of the requirements of.
Right, now it's at the discretion of the court. Okay, yes, and I think we're all kind of on that page. Okay, thank you. Anything else, Mr. Martinez?
No.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. There was a Killebrew agreement that was reached between the prosecutor's office and your attorney that agreed that there would be no upfront jail in this matter. And that's different than a Cobb's agreement that would have been struck between the attorney and the judge. So the court does follow the Killebrew agreements because that is part of the plea. So Mr. Martinez, I understand what your attorney is saying, and as a former defense attorney, I understand why he's saying that. But in this case, the fact that it was a decoy is irrelevant because you were talking to someone that you believed was 13 years old, and you were going to meet her at the Tecumseh Inn to have sex. You acknowledged that you thought she was 13 years old and that you wanted to eat her pussy from behind and make comments how you wanted to marry her and get her pregnant. So, you know, in this case, that is predatory conduct. And so some of the terms under the court's discretion, you will be required to follow. So it's sentenced the court that you will be placed on probation for a period of 5 years. You will remain on the sex offender registry for 25 years. There's $750 in court costs, $130 crime victim rights fee, $68 in state costs, $60 DNA fee, $30 per month supervision fee with no tether, $60 with a tether. And I will give you 4 days in jail credit. During the term of probation, you will obey and comply with all the articles of probation. You're not to violate any criminal laws of any unit of government. No contact with any individual 17 or under, or either directly or through another person. Complete sexual abuse prevention programming or other treatment when referred to by the field agent. You must not reside, work, or loiter within a school safety zone defined as 1,000 feet from school property, developmental kindergarten through 12th grade, unless you meet a statutory exemption. You cannot be within 500 feet of parks, municipal swimming pools, playgrounds, childcare centers, preschools, arcades, other places primarily used by individuals aged 17 or under without approval of the field agent. As we said, you must register as required under the Michigan Sex Offender Registration Act. Make sure you understand the requirements of that law because failure to do so could result in another felony. You can't leave the state of Michigan without consent of this court. Your prior record shows no issues with alcohol. I will strike that clause. You are not to use any illegal controlled substances. You must test as required. Can engage in any assaultive, abusive, threatening, or intimidating behavior. And you must submit to search of your person and property, not limited to, but including your car, your residence, your computer, your phone, without need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. Now, you do have the right to appeal this sentence, and so we are going to mail to your house 3 copies of your notice of right to appellate review. And there's gonna be a self-addressed stamped envelope in the envelope as well, and one of those copies will be marked for you to initial and date. Fold it up after you initial and date it, put it back in that self-addressed envelope and mail it back to me, put it in your mailbox or a drop box. The other copies are for you, and if you wish to appeal this sentence, you would fill them out and mail them within 42 days. All right, Mr. Martinez?
Yes, I understand.
Here, the only other thing I didn't add was that he is currently homeless. So just for reporting purposes, I just wanted that to be on record.
Okay, so do we not, Mr. Jones, have a valid address? Can I give you that for him to resign next Tuesday when he reports, or?
Yeah, I'm actually gonna have him report on Monday morning at 9 AM because I'm off the rest of the week after that. So Monday morning at 9 AM, and I can take care of that for you, Judge, if you need be.
Okay, so Mr. Martinez, I need you to go see Mr. Jones on the 3rd floor of the courthouse Monday morning at 9 AM. And he'll have your appellate paperwork for you, okay?
Okay, sounds good.
I would say that he needs to go to law enforcement today then and report homeless because he provided me an address at the interview. So he'll need to update that now that he's been sentenced.
Where does he go to do that?
Just across to the sheriff's office.
Okay, so sir, you'll have to go to the sheriff's department today to report yourself being homeless for registry purposes, all right?
Okay, sounds good.
Okay, all right, thank you.
Thank you.
Thank you.
You're welcome.
All right, so Mr. Dagmar goes in. We also have Mr. Rowley.
If it's okay, I'll talk to him too. He's on Zoom. Oh.
He's not here. Do you want to try to reach him?
I can try that.
I think. Okay, if you want to try to reach him, you can. If not.
Sure, I will. Let me try to do that now.
Okay.
Middleton.
Hi, this is Judge Anzalone. I am ready for Eduardo Benavides again.
Okay.
Okay, thank you.
Yep.
Hey.
With Mr. Benavides. He's getting on, it sounds like he's getting on screen. I'll go talk with him on Zoom and go over things.
Mr. Daly and you're both gonna go back there?
I think just me, unless Jimmy, you want to go back there, I'll just talk. I'll just talk. Thanks, sir.
Mr. Benavides and We're just waiting for the jail, Mr. Daggerman goes in.
Okay, thank you.
All right, so Mr. Benavides and Mr. Dagger Margosian, I'm gonna open up a breakout room, so go ahead and join that and take all the time you need. I don't have anything else going on, so. I'm back while they're talking. This is Adams.
You want to go back there, Mr. Daly?
Yeah.
Okay. Here. Hey, John.
Hey, you got a jail list?
Yeah,
Is Robert Love in jail?
he's not on the list.
He's not on the list.
You think he might be?
No, I knew he got a new charge, but he's not here.
Do you want me to wait? I'll check with him, see if we can call over. How's Arlene doing?
I don't know, I haven't seen her, I know that went up to see her twice, and I said, well, I assume she's out.
Yeah, yeah. And her surgery anyway.
Yeah. I'll probably see her this weekend.
Yeah, okay. John, it's not scheduled till 10.
What's
It's
that?
scheduled at 10.
It is?
Yeah.
It's scheduled on the night.
Yeah, it's at 10 o'clock.
I will be back.
Okay.
We're all set, Joanne.
Okay, thank you, Mr. Daly.
You know where all the prosecutors are at, Joanne?
No,
I've seen them. There's no prosecutors.
aren't there? No, I have no idea.
How was you gonna be? I was gonna say, you're gonna be getting close.
Yeah.
Please rise for court's now in session. Maybe see.
Okay, so let me bring Mr. Benavides back. They want Gordon too. Oh, and what? Sam here this week?
I think he's downstairs right now.
All right, Mr. Benavides, we are back. So, Mr. Benavides, we also now have Michael Dagger-Margosian here with Mr. Daly. And Mr. Benavides, we sent over to the jail a copy of the pre-sentence report. Did you get that?
Yes, ma'am.
Okay, and then I put you in a breakout room with the attorneys. Have you had enough time now to speak with the attorneys?
Yes.
Okay, are you satisfied with them as your attorneys and the advice that they've given you?
Yes.
All right, Mr. Daly or Mr. Dagger-Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No.
Okay, before the, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Mr. Daly? Dagger-Margosian?
None to my knowledge at this time, Your Honor.
All right, probation department calculated the minimum sentencing guidelines on file number 24-21986FH to be 0 to 11 months. Do you agree with that calculation of guidelines?
Yes, sir.
So there was guidelines ran as well on 24-22076FH, which is a use of methamphetamine. And so the guidelines don't apply to that one because it's a one-year misdemeanor. So I'll strike that one. Okay, we like to be thorough. So before the court passes sentence, Mr. Daly, is there anything you'd like again to say on behalf of Mr. Benavides?
Yes, Your Honor, as I was indicating earlier, Mr. Benavides is in jail. He's prepared to do whatever jail time that he has to do. But as long as this court has the keys to the courthouse and can put him back in there for not complying, this would be a good opportunity to let him know with certainty that he's going to have to comply. And if he doesn't, he'll end up back in jail. Otherwise, he can sit in jail for 11 months. And when he comes out, we're still going to have that problem to deal with. So I'd ask the court to consider something like that. Mr. Benavides is going to have to quit using drugs while he's on probation or be incarcerated. He knows that, explained it to him. His other attorneys explained it to him. Whether or not he listens to us or not is totally up to him.
The recommendation is for no probation. Mr. Dagger-Margosian, anything you'd like to add?
Judge, I'll just piggyback on what Mr. Daly said. Obviously the recommendation is for jail and no probation. This court knows better than most courts dealing with the recovery court, that these substances are powerful, and he's not trying to do bad, but unfortunately he is in the crosshairs of addiction, and Mr. Benavides understands that he is going to have to clean this up moving forward. And just kind of as an example, when Mr. Daly and I were in the back talking with him, we said, look, you're gonna do some jail, and when you get out, but you're gonna get out at some point, and when you do get out, you gotta straighten up, and he acknowledges it, and he's trying to be a good person. Unfortunately, like I said, he is in the throes of controlled substance use and addiction, which is it's a challenging problem that we have. And but I just want to reiterate that I think that Mr. Benavidez has better days ahead of him. I would ask the court to consider his guidelines being 0 to 11. I would ask the court maybe to consider not the full amount. It's obviously the court knows that just throwing somebody in a cage for 11 months is not the solution. Obviously, there does need to be repercussions and penalties and that sort of thing. But I would think that a lesser term would accomplish that same goal. Of course, discretion to do that. Obviously, you're well versed in doing that. So we'll just defer to the court in making that decision.
So Mr. Benavidez, your brother is here, as he always is, here for you because he loves you and he supports you. And then are you another family member? And your nephew's here as well. So Mr. Benavidez, we've spoke to you. I know you've been screened for recovery court, and now you've had an opportunity to speak to your attorneys. Mr. Benavidez, this is your opportunity to speak, and what do you want?
What I want to I just want to, do what I have to do and come out back to society and get my life straight and get back to work, and put this behind me. That's what I want to do.
Okay. So do you want to, I know you don't want to be a part of recovery court. You were pretty clear you didn't think that drugs have had a negative effect on your life, and that you didn't really believe in substance abuse treatment. It's not something you feel you need. I know you've been, you had worked previously at Michigan Pellet. So, are you asking for probation and assistance or help? Or are you asking for just jail and go on your way?
Yes, that's what I'm asking.
Say it again, Mr. Benavidez.
Just to be to jail and go on my way.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law and protection of society. I am 13 years older than you, Mr. Benavidez, and I just, I look at you and you have family support and you have people who love you, and a lot of people don't have that. I mean, a lot of people show up here and they don't have family members. I release them from jail and they're homeless. You have a really good support system and people who want you to be happy and healthy. And somehow I feel like you don't want that for yourself. And that breaks my heart because I think you are worth more than that. So it's a sentence of the court that you will serve 6 months in Lenawee County Jail. On both files, I'll give you credit for time served of 79 days. On each file, there is $130. No, I'm sorry. On 24-21986FH, that's felony. So there's $130 crime victim assessment fee and $68 in state costs. File number 24-22076FH. There's $75 crime victim assessment fee and $53 in state costs. You do have the right to appeal this sentence, so we are going to send over to the jail on each file 3 copies of your notice of right to appellate review. They'll have your initial and date, 1 copy from each file, and they'll send us back to us to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Am I missing anything, Mr. Jones?
No, I think that's good, Judge.
So Mr. Benavidez, the world has changed and we have a great recovery program. And obviously, this time you're not interested in that, but we have many programs throughout the county. So if you were to walk in the front door of the sheriff's department or Adrian Police Department and turn in drugs and say, I need help, they will help find you a rehab. They will help find you outpatient treatment. If you walk through the door of my courtroom and you say, I've hit rock bottom and I need help, I and my staff will help to make sure that you get programming and help that you need. So, Mr. Benavides, I wish you the best of luck. Thank you.
Thank you.
All set, Mr. Benavides.
Thank you, Your Honor.
Thank you. Thank you, Mr. Benavides. Thank you. All right, Mr. Degemargosian, we have Ms. Rowley, and he is not in custody, so this is in the matter of where'd he go? This is wait, he's gotta come back. It's, Raleigh is supposed to be a sentencing, right?
Yeah.
Circuit court sentencing? No, district court, that's fine. All right, so, do you need anything, Mr. Benavides?
Yes, I was gonna talk to him.
Oh, go ahead, Mr. Degemargosian, you can talk to Mr. Benavides. You want these? Mr. Raleigh, Miss Adams did just remind me that he's the one that was waiting for a license.
To get his fingerprints, yeah, because he had, the whole thing, he was trying to get fingerprints, he didn't have a license, so that's all right, that's all I.
Mr. Sneed, if you show up, you're here on everything now. So, we were here on January 10th. I gave service in person. Does show that, oh, maybe I mailed it out. So this is in the matter, but I do have fingerprints. Hold on. So, all right, we'll not issue a warrant. Okay, so, okay, the matter of the people of the state of Michigan versus Joshua Dexter Rowley. 2 files, 24-21911FH and 21957FH. So it looks like he missed a sentencing date before, and you guys, he reached out to you, so we didn't issue a bench warrant. And then he needed to get an ID. So have you had contact with them, Mr. Degemargosian?
I'm sorry.
Have you had contact with them?
I haven't, throughout the pendency of this case, his contact information has changed, not by his own fault, but it's just changed, and so I don't even know if I have his updated current phone number. Maybe I can double check what the court has for him.
We don't. I know Leo that works for you had phone contact or made contact with him back in December.
And that's the number that I just tried, so I can't get a hold of him.
Well,
and Mr. Riley was here in person last time, correct?
No.
Or on Zoom?
So it looks like, so the last time, January 6th, no, December 20th, January. We can look for notes. If we be quiet for a minute, Ms. Spade, there was a hearing on January 6th. No, hold on.
December 20.
Looks like January 24 was a year on January 24.
Yes, Mr. Degger Magosian was on Zoom. Defendant Raleigh was on Zoom. And Mr. Moore was present in court. The court, unable to proceed with sentence as defendant, has not been fingerprinted. Defendant stated he is waiting for state ID to arrive to have prints done. The court adjourned sentence to 2/7/25 at 8:15. He failed to appear, Judge, on December 20th.
Okay.
When it was scheduled.
So it looks like he was here and given notice, so I will issue a bench warrant for his arrest. I'll set bond in the amount of 5,000.
Here, can I check one thing?
Yeah.
Yeah,
Alright, and I'll set bond in the amount of 5,000 on each file. If you hear from him, I'll get him in right then.
sure. Thank you.
Alright. Okay, and that'll be on each file. What was it, George? 5,000 cash, okay.
Thank you.
Alright. Rally, Benavides. Nolan, so. All right, I have Mr. Steen, so we have a bench conference on Mr. Gorton. So